I like that. Ladies and gentlemen, welcome to room 592. As we also say, welcome to our esteemed guest tonight. And just before I make an attempt at introducing such an esteemed guest to the Guyanese population, let me say, ladies and gentlemen, from wherever you're joining us from all across Guyana, and of course the Caribbean, United States, Canada, UK, and hello to our guests who have joined us all the way from Australia, Ireland, New Zealand, and everywhere else. Welcome to room 592, where we unleash the truth. It has been an a very, very eventful couple of days, ladies and gentlemen. It has been a very sad, bleak year for Guyana thus far. We have had a year in which we have seen Guyana almost going off the precipice, going off that cliff, almost at the point of no return. But there has been some cases at which we stop and we think and we say that there are still people, reasonable men and women, who are ready to argue for the rights of our people. Ladies and gentlemen, over the last couple of days especially, we have seen Guyana go once again to the CCJ. May I remind you, a year ago, we were embarrassed that we had to go to the CCJ to learn that 33 was a majority of 65. We had a problem with math. And a couple of months ago, we had a problem with English when we had to go to the CCJ again. And that is all behind us when recently we had to go right back at the CCJ, this time for comprehension skills. Ladies and gentlemen, it is extremely worrying that all of this is being done, and from my own humble view, I'm not speaking here on behalf of my guest or this radio station, I'm speaking purely from a personal perspective. It is a sad state of affairs when a government has been voted out of power since March 2nd, 2020, and 4 months later, clinging on to power at all costs, notwithstanding our deficit in the central bank holdings of more than $70 billion. 14 billion in gold has disappeared. Nothing. This country is almost broke and bankrupt. And it speaks to the broken, bankrupt morality issue, that is with our politicians. Ladies and gentlemen, sorry to be carrying on, but it is something that I'm passionate about, how we are managing the affairs of this country. Tonight, we are going to have a wonderful discussion with somebody who has stood as a champion for not just constitution and elections, but a champion for people across the Caribbean. Ladies and gentlemen, may I just take a moment of your time to tell you that tonight we are being joined by a leading elections lawyer across the Caribbean, a legal luminary out of Dominica that has practiced in the Caribbean and in the OECS, a former head of the Bar Association of Dominica. He is one of the highest profile senior counsels in the OECS and has represented the interests of many prime ministers, governments, politicians, you name it. Mr. Astaphan has seen it. He's been there, done that quite literally. He was a lead counsel for Mr. Denzel Douglas, leader of the St. Kitts and Nevis Labour Party and former Prime Minister of St. Kitts and Nevis. Guess what? More succinctly put, ladies and gentlemen, from around 1998, this distinguished gentleman has been involved in almost all of the elections petitions filed in all of the member states of the OECS. In fact, there were times when he was in one island physically and doing election petitions or constitutional matters simultaneously while preparing election cases in another jurisdiction. He has done in excess of 100 election petitions, more than any other attorney in the Commonwealth. He has represented the prime ministers of the OECS, Mr. Lester Bird, Mr. Gaston Brown, Mr. Roosevelt Skerry, Dr. Ralph Gonsalves, Dr. Kenny Anthony, Dr. Denzel Douglas, as I said earlier. He has done an enormous amount of constitutional law matters ranging from issues concerning the right of opposition parties to the right to have access to state media, which, as you know, is something I have been really outspoken about here, that state media aspect. This distinguished gentleman has had the powers of the DPP to, well, he has questioned and has provided and fought for rights and access to powers of DPP to institute criminal proceedings, for example, actions taken against unlawful exercise of state power, the use of abuse of state resources and use of state resources, the compulsory acquisition of land, and these are just to name a few, ladies and gentlemen. To put it plainly, Mr. Anthony Astaphan is well respected across the Caribbean as the go-to attorney for constitutional and electoral matters. He would have appeared on countless occasions before the now President Justice Saunders, the past President Byron, current Justice of CCJ Dennis Barrow as well. Ladies and gentlemen, it is with distinct pleasure, honor, of Kaito Radio, of all of Guyana, and of course, on my own behalf and that of my co-host, Mr. Gildari, to say, welcome to room 592, Senior. Senior meaning, to ladies and gentlemen out there, Senior Counsel. A man who is senior, not in years, Senior Counsel.
Thank you for clarifying that. Thank you so much for having me.
Thank you. You're welcome. And sir, I would like to start our discussion tonight, if you do not mind, by reminding you that it is in your representation of people, sir, you would have addressed matters of electoral dishonesty. Electoral dishonesty was addressed by you when you had cause to speak about the dishonesty of persons in public life and refer them to the Halsbury laws of England on bribery being the intent of having voters vote because of inducement. And sir, I must say, you said these words a couple of years ago that I would like to quote because I'm going to replace the island you mentioned with Guyana because it is so apt. Ladies and gentlemen, here is what Senior said. There are very few times in the history of a nation when the political options are as dangerous as they are now in
blank, blank, blank.
We have in this land a political person whose fractured track record is one of deception. No, he wasn't talking then about Mr. Granger or any politician in Guyana. He was talking about the political trying times in Dominica, his home country. So, sir, I would like to, upon reading that quotation from yours, to say this rings true of Guyana. You have seen what's happening here, sir, and may I ask you for your opening ball, as you know, we like cricket in Guyana, for your opening ball into what's in your mind taking place in this Guyana election scenario.
Well, I put it slightly different to how you put it. I think it's a blessing we have the CCJ. And I think on two very important historical occasions. One, the mathematics about 65 and 34. And the other one you said about comprehension. Well, it's a bit more than comprehension. We can get into that a little later on. And had it not been for the CCJ, and had it not been for the comprehensive judgments that were delivered both in relation to the motion of no confidence, the challenge to Mr. Prasad, I think his name was, and today, the bewildering submission that 34 was the majority of 65. I think we would have had some very, very sad and troubling days concerning the rule of law and democracy in the Caribbean, because these judgments apply with significant force to the rest of the OECS islands.
Absolutely. You are right, sir. And let me just say this in welcoming Mr. Sanjeev Datadin, one of your colleagues. And Sanjeev, I must say this to you, and I say this to you as a person I respect and friend. Sanjeev, welcome to room 592 JC, because tonight we have SC on board.
What is JC for?
Junior Counsel, man.
Junior Counsel.
You can't do that to the man.
No, that's okay. Sanjeev doesn't mind. So, ladies and gentlemen, let us also welcome Mr. Sanjeev Datadin to our room 592. Sanjeev, welcome. And we just did an introduction that I don't feel can really speak to the accomplishments of our distinguished guest, Mr. Astaphan, tonight. But of course, we try our best. Sanjeev, welcome once again, sir.
Yo, good evening to you. Good evening to Leonard. Good evening to Anthony, all the way in Antigua. And of course, good evening to my beautiful wife. Let me help you. Let me help you with the introductions on Anthony. Anthony is an exceptional senior counsel practicing mainly in the Eastern Caribbean. And in matters that involve election matters and election disputes, I don't think, if we simply go by the reports, that there is any other attorney that has done as much of them as Anthony has done. I don't think there is anybody else that has done as much as he has. The other thing is, I've known senior counsel for many, many years, close to a decade. I have never, ever, I told him this yesterday, seen him with hair. Ever. So you're very privileged, Yo. But if you look at the reports, if you look at the law reports, the reputation of Mr. Astaphan speaks for itself.
Of course.
He is one of the unique senior counsel in the Caribbean. In all the time that I have known him, I can tell you, he is a text away, he is a phone call away. He's always available to be of assistance to you if he can. He's always available to discuss even the most obscure matters at odd hours of the night and day. He is truly what a senior counsel embodies. I am lucky indeed to have known him. We've been opposite each other, and similarly with senior counsel Mendez. They are really two peas in a pod. And so his reputation precedes him around the region. He is well known.
Great. Well, we are certainly honored to have you here tonight, Senior, as I said. And ladies and gentlemen, I want to open our discussion tonight by reading the following. Senior, I think you would be delighted to hear the words that is contained in the letter from the chairman of GECOM addressed to the chief elections officer. Ladies and gentlemen, today, the chairman of GECOM sent the following letter to Keith Lowenfield, and it reads as follows. Very short, but very, very plainly spoken. Section 18 of the Election Law Act number 15 of 2000 stipulates that you are subject to the direction and control of the Commission. In accordance with this section and pursuant to Article 177 2B of the Constitution and Section 96 of the Representation of the People Act, Chapter 103, you are hereby requested to prepare and submit your report on March 2nd, 2020, general and regional elections by 2 p.m. on 10th July 2020, using the valid votes counted in the national recount as per certificates of recount generated therefrom. End of message, end of mail. Senior, are you happy to see the language contained therein, sir?
Yes, I am, because the chairperson of GECOM is making it clear that he has to use the certificates of return that were published, that were written up under Section 89(1) of the Representation of the People's Act in accordance with Form 24. And that's, and just to make sure, 'cause there's going to be some discussion about valid or whatever have you. Paragraph 2, total valid votes for all lists. And what the chairman means by the word valid votes is that the Representation of the People's Act, from about Section 83 right through to the very end, has a process for determining, put it in the negative, what are the invalid votes? Because votes, I mean, every vote cast is presumed to be valid, unless questioned during the count before the presiding officer, and he puts them in an envelope and he says question, and his decision on these questionings are final, subject to review by the returning officer. And then on the recount before the returning officer, his jurisdiction to determine a valid vote invalid is limited to things like missing the mark, no vote is disclosed, and so on. So the chairman, and I'm giving a longer explanation than normal so that the listeners understand that she's not asking about the valid votes that the chief elections officer was speaking about. She's speaking about the valid votes listed in the certificate of returns, which he was required to do under, I think, Section 89 of the Section 87, sorry, give me a minute. Section 89 of the Representation of the People's Act in accordance with Form 24. Yes. And by making that demand on him, and she made it very clear he's subject to the directions of the commission, that she does not want any intermeddling with the quote-unquote valid votes that were counted at the final count under the, well, before the observers and representatives of the parties and so on. So that's a significant step forward.
That is indeed, and the way you have put it, Senior, that is indeed significant. So ladies and gentlemen, just to remind you all that the way this letter has been designed and addressed to Keith Lowenfield does not give Lowenfield the laxity of applying his own interpretation of what valid votes mean anymore. She has provided the context, the form, the statute, everything that he needs, as counsel would have pointed out here, to say these must be the valid votes that you must bring to me. Counsel,
so the valid totals. Let me be clear, because on Form 24, if I can show it, this is Form 24.
Yes.
This is the certificate. Do I have it right?
Yes, it
is. This is the certificate that I have here.
Correct.
And that needs to be issued by the returning officer after the count. And it says, number one, for the polling district, is coming out good for the polling district of blank, number of valid votes cast for each list of candidates, list of etc., total valid votes for all lists, and the total number of rejected votes, etc., signed returning officer. It is the valid votes disclosed on the returning officer's statement that I think the supervisor is referring to, and not the calculations or the judgments or the subjective calculations of the supervisor of election.
Correct. Senior, I hate to put this to you. Do you see any leeway? Do you see any slack area here that the CEO or persons who are advising the CEO may say, well, go back with the same, that allows him to go back to the same June 16th submission he would have made?
Well, that would be complete disregard of the ruling of the CCJ. I mean, as I said on another station last night, one of the fundamentals of our constitutional governance is the separation of powers.
Yes.
And if the court gives a ruling in whatever form and in whatever language, and making it clear that what had happened previously up to the decision of the majority in the Court of Appeal was unconstitutional and wrong.
Mm-hmm.
I think the separation of powers principle demands mutual respect and reciprocity from the executive branch. So I don't know where they can go beyond the judgment of the CCJ, and I don't think there's any ambiguity in the chairperson's letter, especially as the certificate of return she's referring to were as declared after the recount, and not without deductions of suspicious, quote unquote, whatever you want to call it, to that led to the disenfranchise of 100 and something thousand votes. I mean, I have never in all of my years come across any electoral commission or any chief elections officer that has tried without due process under the election jurisdiction of the court. That's entrenched in section 163, I think, of the Constitution, to disenfranchise people on allegations made by an opposition party or another party without a petition and due process. It was a mind-boggling statement to hear.
Correct. And Senior, if you don't mind, let me ask you this from a more personal basis. What would have gone through your mind and colleagues of yours when you would have seen and heard what is taking place with the Guyana elections and the twists and turns here?
Well, I want to be careful what I'm saying. On a personal note, it was disappointing. It was not what was expected. The Caribbean in recent times has a history of smooth transitions in election matters. Sometimes politicians win, sometimes they lose, but I don't think that they should do their very best to stay into power, regardless of what the vote count is. Let us even put that on the understandable list. It was the some basic facts that need to be mentioned. The observers were here for the actual vote, the ballot, putting the ballot in the box. They all said that was a free and fair election, and the election represented the free will of the Guyanese people. And I think they came to that conclusion even before the count started. Where I think the trouble began, it's when the returning officer for polling district 4, I think it was, 4, came up with a calculation that seemed to have ignored the statement of poll. Now, the statement of poll, for your listeners, I'm sure by now the Guyanese are absolutely saturated.
We're all experts now.
Correct. But seeing that I'm not the expert, maybe I'll try to explain it to the expert.
Please.
The statement of poll that was prepared under section, if Sanjay can shout out the section for me if he's still on. Section, anyways, a subset.
84.
84
relates to what happens at the statement of poll. 82 and 81.
Well, my pages are a bit mixed up, but I can tell you, subsection 9 says, after the completion of the counting, the presiding officer shall complete the ballot paper account and tendered ballot paper account in Form 23. And I know what's happening. I have a couple pages missing. Anyway, and statement of poll in Form 23A, and prepare and certify a sufficient numbers of the same, meaning the statement of poll, for distribution as follows: returning officer, assistant presiding officer, to such duly appointed candidates or polling agents as the president and the chief elections officer. The next section is the part of fundamental importance as well. 9, in a statement of poll prepared in accordance with subsection 9 shall be posted in a conspicuous place outside the polling station,
Yes.
polling place, as conclusive evidence of the result of the election, unless there is a recount of the votes.
Yes.
So at that time, the returning officer for District 4 was, I think, suggesting that his count was different to the statement of poll.
Right.
That raised, I think, a red flag among a number of people. That when you get to the recount, bearing in mind the fundamental importance of the count before the presiding officer, when you question a vote, that's a broad terms, question a vote. Correct. And the presiding officer is to make a notation. That vote is questioned, and his decision is final and next set aside on the recount. I do not know whatever happened, whether there were any reviews of a presiding officer's decision at the recount, but the returning officer at section 87(2), this is the fundamentally important section that helps us to understand what is meant by valid votes or invalid votes. When a returning officer is required to have a final count of the vote cast for all, some of the polling places he shall have in the presence, he shall do the following in the presence, A to E. In counting the ballots, the returning officer shall, subject to subsection 3, reject as invalid. This is why I didn't understand what the Court of Appeal meant by valid votes, because all votes are presumed to be valid. But the legislation gives the returning officer the right to declare certain votes invalid on the following grounds. Not because you lived in New York, or you may have voted from Rosa Dominica, for the following reason: which does not bear the official mark, A, B, which has not been marked for any list of candidates or is void for uncertainty, C, on which votes have been given for more than one list of candidates, you understand the Guyanese election process there, on which there is any writing or mark by which the elector can be identified. And the other matters which makes it, which say that for if these A, B, C under subsection 3 were to occur, they shall not be rejected solely on the basis. Right. So once the process of the presiding officer is complete and the returning officer's jurisdiction to declare vote invalid is strictly limited by statute, how the supervisor of election got to assume the power that he did simply on the basis of some allegation made in the process is really difficult to follow. And I'm not quite sure why the Court of Appeal was asked to interpret that to mean valid votes, because under election law, every single vote is presumed to be valid unless ruled otherwise by the presiding officer on a question, when a vote ballot is questioned, or for the following statutory reasons which I gave you.
Right.
Any other setting aside of a ballot or an election, as the CCJ says, all the allegations made by Hammond could be dealt with judiciously in accordance with the protection of the law, with the fullest protection of the rights of the parties by an independent court by election petition. I'm sorry I took so long, but it was very important for me to explain that.
Absolutely. That is very important indeed. Counsel, I want to ask you, and Sanjeev, if you could throw in your thoughts afterwards as well. Paragraph 52 of the CCJ's decision, decision that it issued, states that the court also notes that an order issued by GECOM in any particular context can never determine how the Constitution is to be interpreted. It is a matter of elementary constitutional law that if ordinary legislation is in tension with the Constitution, then the courts must give precedence to the words of the Constitution and not the other way around. With respect, the notion that Order 60 could either impact interpretation of the Constitution or create a new election regime at variance with the plain words of the Constitution is constitutionally unacceptable. Counsel, the reason I've read this out is that all of today, one of the stakeholders in these election processes, one of the main stakeholders, would have used this paragraph to say that the CCJ has thrown out the importance of the recount itself, to say that the Order 60 has nothing, the CCJ has discarded the Order 60 by saying it doesn't have any importance and blah, 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 and that they're now asking that GECOM revert back to that, in my own words, fraudulent declaration of early March 2020. Is there any sanity, sir, in this presumption?
That's my director making sure I look okay. Otherwise known as my wife.
Okay, great. And our hello to her, sir.
Sure. Portia, hi. I think I have to be careful. But I've heard so many interpretations of the law of Guyana. And I've heard so many pronouncements as to the effect of the law of Guyana. Now I'm getting pronouncements, and I've seen some of them on the interpretation of the judgment. And a very old lawyer once said to me sometimes, when you hear conflicting opinions that are so way off what could be a fair reading of the document or the law, you need to check your library to make sure there's some other edition of the current text that may have come and changed the law. And I don't understand how anybody could have reached that conclusion. I really don't. And it's unfortunate. And what I also think was extremely unfortunate was the attempt to either influence public opinion against the CCJ or to influence the CCJ in some way with advertisements in Trinidad and with the constant statements from lawyers, some very prominent lawyers, about the decision is final and all of that. And I think that's regrettable that happened, because we have had it in the OECS a couple times. I disliked it then, and in here in the OECS, and I sincerely dislike it, the way it was done with the CCJ, for the specific, particular, and personal reason that too often our politicians see the CCJ as a political football, as an easy target, because they won't respond. And the fact that we've had referendums in Grenada, in St. Vincent and Antigua to try to get the population on board with the CCJ, and this sort of assaults on the integrity of the CCJ are simply mind-boggling. And to do that in a referendum, one can say, well, everybody's entitled to say whatever he wants. I don't agree with that, but that's the general accepted premise. But when a matter is pending before the court of the highest constitutional importance, I would have thought the parties on both sides would have sought to exercise considerable restraint.
Correct. Sanjeev, your thoughts on what would have been transpiring on the political front today with regards to the interpretation of the decision of CCJ? Seems like we have lost Counsel Sanjeev Datadin there for a minute, and until he gets back. Counsel, in terms of the decision of the CCJ itself, as a man who has been practicing across the Caribbean, you have single-handedly managed all the election petitions across the OECS, and you have been part of everything there, Senior. So in terms of your own experience, does the decision of the CCJ yesterday place you in a position of being proud of law and being proud of yes, the decision of where it's coming from?
Yes, and I think that's an advantage that Douglas Mendes, who is an absolutely great lawyer and great friend, would have had, because Douglas and I have fought against each other in Antigua. We fought against each other in Nevis. I regret to say that I lost in both occasions in the Court of Appeal. Mm-hmm. But we fought against each other in Dominica. I'm happy to say that I won there. Good. We're going to have a battle in St. Kitts. Are these battles have given, and in St. Vincent we were on the same side, have given us an understanding of the election law and indeed public law issues that I think was important, especially for him, because he was actually leading the fight. I was merely in the background taking phone calls from Sanjay and others and passing information on to Douglas and so on. When he called, that gave him a considerable advantage. And I say that with all the greatest respect to all the lawyers who appeared, because I listened to the submissions that were made to the CCJ, and it was fairly clear that obviously they were following instructions. But the genesis of the problem, I'm not blaming the lawyers, the genesis of the issue that compelled the arrival at the doorsteps of the CCJ was premised on a fundamental misunderstanding of the election law by those who started the process and instructed these laws, because it was difficult to explain that how does a chief elections officer assume that level of authority to disenfranchise, well, maybe not one, perhaps two, 100,000 without due process, without evidence, without nothing, without the participation of all of the parties. I mean, I just find that
right.
And then to seek solace in the law and to seek refuge and asylum in the law by suggesting that you're seeking an interpretation of the Constitution when the entire frontal attack is on the actual count itself and GECOM's order.
Correct.
Was something that I never in my wildest dreams expected to see, but it happened, I saw it, and I was equally confident, though, on the other side of the coin, that the CCJ were not going to go along that line, because some of these judges have had to deal with election petitions, either as lawyers or as judges.
Correct.
Good to see you, Sanjay. I couldn't see you before.
So, Counsel, I'll come back to you on another to ask your opinion. Senior, I'm going to come back to you to ask your opinion.
Sure, no problem at all.
With regards to what you would have, what would have been your thoughts when you saw the attack on the CCJ, the political attack they had spent in Trinidadian newspapers and so forth. But Sanjeev, Counsel, I want to come to you to ask you what's your opinion of the what transpired today, because the stakeholder APNO AFC has been latching on to paragraph 52 of the decision to say that has thrown this entire recount out of the window, because it's saying that section 60 or the 60 cannot interfere with the Constitution and all of that. You have seen it. No need for me to explain further. Over to you, sir. You're muted.
Yes, Sanjay, you're on mute.
Yeah, Yog, the reality of the situation is this. What they are saying as it relates to paragraph 52 of the judgment is, first, is inaccurate. It's inexplicable that they would think that that would be a fair interpretation. But then again, we had to deal with 33 not being a majority of 65. The reality of what that paragraph simply means in the judgment is, whatever that you think is in Order 60 that is inconsistent with the Constitution is not applicable. But you have to realize what it is that they were talking about. They were talking about the parts of Reynolds' judgment in the Court of Appeal, which dealt with qualitative and quantitative assessments. And what the court was at pains earlier in the judgment to say is that all the issues of validity as far as GECOM was concerned has already been dealt with. It is dealt with at the lower levels by initially the polling officer when they do the count on election night, and secondly, it was done by the supervisors at the recount. And those were where the votes were valid and determined. They made it very clear that Mr. Lowenfield had no part to play in that, because you have to look at it logically, Yog. Lowenfield was never seeing the ballots. He was never observing anything to do with the ballots. All Lowenfield received were various, what should I say? I don't want to say pieces of paper, various statements, which all have the statements of the recount for the 10 regions. That's what he saw. How could he rely on that to say that he would determine validity or not? Now, the court was also at pains to point out that the 20 odd letters that Mr. Harman wrote on behalf of APNU and the complaints he had about dead migrants and otherwise anything else that he claimed to be an irregularity fell squarely within an election petition, and that Lowenfield, if he was choosing to exercise any authority then to determine validity, was trespassing on Article 163.
Right.
So the explanations were very clear. Lowenfield's job is to tabulate those 10 statements of recount and present it to the commission. Now, what was being peddled by APNU is somehow or the other, they are giving their supporters false hope by saying that, look, Lowenfield can decide what he wants to do, and Lowenfield has done this before, and he might do it again. But he has no pathway. The court was very, very clear that these are the things that must take place now. And what, the court made a very strong statement about the insertion of the word valid, the adjective of valid votes by the Court of Appeal, was taken as an invitation by Lowenfield in violation of the court's order when there was a stay to present a report where he arbitrarily, apparently, decided without any transparency to remove votes that had been there. And he discarded 15,000 votes without explanation. So they pointed out that what the Court of Appeal did was not in fact an interpretation of the Constitution. As Senior Counsel has been at pains to say, all votes are valid until you decide that they're not valid. So there was no need for that interpretation. But the CCJ was clear that was a pretend interpretation, when in fact the Court of Appeal was focused on what were the contents of Order 60 and saying that the qualitative and quantitative thing as to credibility had to be applied. But there was no basis for them to do that. So what is being said today, Yog, by APNU and its supporters is entirely erroneous. What is being said is a violation of English language when they read it for what it actually means. It does not mean that you could go back to Mingo's numbers for a declaration. That would be preposterous, Yog. The whole nation watched in the recount and observed day by day Mingo's numbers were proven to be fraudulent. How could we decide that you go back to that by any stretch of the imagination? That's not possible.
Correct. Thank you for that, Counsel. Senior, I'm going to come to you again
May,
with a question.
may I just add one matter there?
Sure, sir.
Section 54 was making it absolutely clear that the applicants could not use the GECOM's order to circumvent the very strong language in Section 47 that Sanjay referred to without actually reading it, because it said that the issue of the validity of the votes, once you pass the initial stages of the count, could never be determined by anybody else but the High Court exercise in the exercise of its election jurisdiction. And they could not use any sort of frontal attack or reference to Order 60 to try to craft a jurisdiction for what happened with the Court of Appeal and the Supervisor of Election that does not exist under the law.
Correct.
I mean, I'm giving a legal interpretation. Sanjeev
Yes.
gave it for everyone to understand. But
Correct.
that's what the court meant.
Mm-hmm. So, Senior, I wanna put the question back at you in terms of, have you seen in any other jurisdiction? You did allude earlier to political attacks on the courts. Have you seen any other jurisdiction or in your history that these kinds of attacks would have been made on the CCJ? And my second question to both you and to ask Sanjeev if he wants to comment after you, of course, sir, is during the Court of Appeals deliberations and in handing down their decisions, Senior, there was in our mind, and this is from a layman perspective, there was some strange emanations. For example, the Court of Appeal alluded and accepted the fact of contextual meaning to articles of the Constitution, in particular 177. But in accepting that there is such a thing as contextual meaning, they discarded it and proceeded to say that we are making a decision that is disjunctive yet not absurd, quote unquote. Disjunctive yet not absurd. And the reason I ask you this is because it was disjunctive in a layman's perspective and absurd given what the CCJ has found. Sir, contextual meaning, isn't it an important part of legal practice?
My friend, all that I will say is that I rather not say much. I mean, we must never bring the court into disrepute, but we must feel free to speak of their judgments. I think that's the benchmark that I want to maintain and not cross. I never understood how 34 became the majority of 65 to start with. Mm-hmm. And I could not understand whatever means of interpretation was used, except that the lawyers must have been absolutely brilliant in their eloquence to create, and you know, the CCJ has used the absolutely correct language, and perhaps it's best that I use theirs. By the unnecessary. An apex court will not use these words lightly.
Yes.
By the unnecessary insertion of the word valid. Means it was not necessary to mention it at all. Why? One of the reasons I gave to you was that all votes are presumed valid. Yes. And unless they're set aside for the missing of the mark and the missing of the this, that they are all valid unless set aside in the election jurisdiction for fraud, impersonation, qualification, etc. The Court of Appeal impliedly invited the CEO to engage, unilaterally, in a further and unlawful validation exercise to and in clear tension with the existing, constitutionally anchored electoral laws. My dear brother, that is language pregnant with meaning. Mm-hmm. And I hope women don't get offended I use the word pregnant, but unnecessary, valid in inverted commas, impliedly invited. All they said the Court of Appeal didn't do was say, Lowenfield, go do it.
That's right.
But an implied invitation is nevertheless an invitation to do something which the CCJ said was clearly further unlawful validation exercise unknown to any clear tension of the existing constitutionally anchored, good Lord in heaven. When an apex court says anchored, it means, well, you can't move it. You can't brush it aside. You can't leapfrog it. You can't just ignore that it doesn't exist. It's there like the Rock of Gibraltar. Mm-hmm. And I think the next section that goes on, they refer to section 163, the idea that the C or GECOM could in an unaccountable, non-transparent, and seemingly arbitrary manner, without the due processes and I'm running out of breath reading it. Legal standards established in Article 16 and in the Act disenfranchise cause of thousands of electors is entirely inconsistent with the Constitution. Surely, it could not just be some of us who thought that that was happening. And that's the perfect description to describe what was happening. The court of the CCJ accurately described it in language which suggests that these tensions and these actions should have been obvious to all, that they were unconstitutional. I don't know if Sanjay agrees with me, but that's my interpretation of it.
Thank you, Senior.
No, I of course agree with you, Senior, but I agree with you also that the Caribbean Court of Justice's judgment that they delivered had very strong language about what was done and what was taking place. They felt very strongly that there was no need to interpret the Constitution in the manner that the Court of Appeal engaged in. They, of course, felt very clearly that the issue had not, the condition precedents had not arisen. One step could not have been engaged, because if it was truly engaged within the spirit and letter of it, then there would have been no right to appeal. But it was not engaged, and that is why there was a right to appeal, because the power that the court had was to make a decision within the confines of 177. And if it did, then that decision was afforded the protection of being final. If it did not, then that protection would not apply. Now, that was the little part of it. The big part of what the court was making a meal of, what the court made a lot about, is the Court of Appeal was making a meal of interpreting a few words in one part of Article 177, which added nothing to it, and which was not really an interpretation of the Constitution. To say valid votes, votes mean valid votes, it was not required. And by doing that, it purported, the Court of Appeal felt that when it was doing that it was in fact interpreting the Constitution within the meaning of 177. And the Court of Appeal, the CCJ said that was not so. But the CCJ went on about what the CEO Lowenfield did in relation to that interpretation. But we have to remember now, the Caribbean Court of Justice was very clear in its ruling. It says GECOM must now ensure that the CEO Lowenfield takes its instructions in accordance with the letter he received of 16 June. He complies with those instructions. The CCJ also said that the chairwoman, Justice Retired Claudette Singh, was correct when she said that those issues that were raised about dead and migrant voters were not for GECOM to decide. They didn't have the mechanism or the legal authority to do so, which is something that we have been saying, and that was what we were saying to the court. How would it be undertaken? Who would be the adjudicator? How do you bring the case? When do you give a hearing to the interested parties? What rules of evidence? By what document do you approach the commission? These are all essential things. What's the standard and burden of proof? These are all essential things that she pointed out they don't have the mechanism to do. Now, we go one step even further than that, Yog, is the court made very clear that Lowenfield makes no determination about validity. Nobody in GECOM has that power. It's gone already, and it's valid. And that what has to happen is Lowenfield has to follow the instructions he's received from GECOM. Once he fulfills that, GECOM is going to receive a report and make a declaration. Once the declaration is made, there's going to be the swearing in of a president. And I think everyone in Guyana is fully aware of what the vote count is. It's been brandished around for more than a month now. Yog, you are in Guyana, and I know you see what's posted on social media. The same is true for you, Leonard.
Mm-hmm.
No one is arguing anymore. None of the
That's true.
FC people are arguing anymore about anything to do with the evidence they have of voter fraud, of it being impersonations of migrant vote. Nobody's arguing about these things, you know. Nobody's raising these things. All they are saying is there is all of this fraud. What are we to do? But they've produced no evidence of it in any.
Yeah.
They have still up to now produced not one iota of evidence. They produced newspaper articles in the Chronicle that was saying that they have produced all the evidence. When you read the article,
Correct.
it's 4 certificates they produced, death certificates, I believe, and they were speculating about how much of the people were migrant voters. But we have to have evidence. No,
and that evidence is what was probably part of the entire thing too, that there is a time and place for that evidence to be submitted in due process to the court, right?
But the court was at pains to say that you cannot continue to interrupt this electoral process in this way, and that you continue to do so, then you're impinging upon, you're trespassing upon the exclusive jurisdiction of the court.
That's right.
And so, if you look at the attacks that went on, I mean, I know Senior Counsel has been around a lot longer in this practice than I have.
But Counsel, before...
I've never seen a full page ad taken out to address a court.
But before you get...
No.
Yeah. Before you get to the attacks, I want to address that as a substantive issue by quoting what Senior said just now. But before I even go to Senior, ladies and gentlemen, if you have not gotten a copy of the judgment of the CCJ, please get a copy. It is interesting read. And if you get to paragraph 42 and 43 and look at what is the interpretation of this Article 177 of the Constitution, and you go to 45, which gives the absolute, long explanation of what validity in context means to this process here. It is important, and all legal students and so forth should really have a look at this thing and latch onto it. Senior, you earlier said, rightly so, sir, we cannot bring the court into disrepute. Sir, politicians have attacked viciously courts that do not abide with their political thinking. And in this case, politicians have even taken out a full-page ad in the home country of the CCJ. As a legal practitioner, sir, what goes through your mind when you see these things, and how does it set law back?
Yog, before you let my senior answer, please warn him that when he responds to this, the attacks of the people he know, like Prime Minister Mia Motley, Onarta, what has happened to them when they have responded about this? And as you can see, the attacks on the CCJ. So, Senior, welcome.
I will be careful.
And
welcome to the club.
Senior, let me say this as well. I mean, our apologies to the good lady next to you there, sir, because the attacks might be coming in you in ways you might not have imagined before. But over to you, sir. Welcome to Guyana.
Well, let me just tell you something. I don't know if it's going to be different. There are some countries in the OECS, I can't walk through the streets unless I get a full-fledged cussing for a few hours.
Wow.
I find myself in a car and then they talk about me on the radio and I sit down and say, is it me they're talking about? Look, I have a number of responses. CARICOM was invited and then subsequently disrespected because CARICOM was not saying what it is people wanted to hear and so on. I was troubled that this campaign against the CCJ or to prejudice the minds of the public was coming from political parties, their agents, their friends, their supporters, their PR people in government, meaning the parties are the ones in government. I have seen opposition political parties attack the court. I have seen opposition parties in Dominica and other countries, they get an first instance judgment. They go on a motorcade. You all have motorcades in Guyana. They go on a motorcade. They go to the Court of Appeal and they lose. And they spend the next 6 months on the radio saying the court is the worst court in the world. We have had an unfortunate situation where 2 judges have had to recuse themselves from the election petition matters in Dominica because the leader of the opposition and his political parties, his supporters have embarked on a harsh, brutal, pejorative campaign against them, and in particular one who's a young female judge. These threats on the court, whether the PR camouflage of what took place in Guyana or the frontal, open, naked, pejorative attacks in Dominica, all have the same effect, which is to undermine the integrity of the court. And it is sad because they would not do that to the Privy Council. They wouldn't touch the Privy Council. I mean, I have heard a leader of the opposition say he feels comforted with 5 ethnocentric gentlemen. I didn't want to use the word white, but 5 ethnocentric gentlemen in London dispensing justice rather than go to the CCJ. I think it was unfortunate. I think it set a bad example. And the problem in the Caribbean, and this is my experience in representing politicians, both for or against, these supporters, my dear friends, these supporters tend to believe almost anything like it's bread coming down from the heavens. Right. They believe everything. They will not think for a moment that that PR smear campaign could even be conceivably off target or wrong. And many times it is, and that's why gentlemen like you and the senior journalists on the other side have a full-fledged constitutional responsibility to educate the population on the facts, which I hope we're doing tonight.
Thank you.
But I want to mention something Sanjay said, because that's probably one of the most important things in this case that the population has not yet fully understood. Sanjay said the condition precedent was lacking. That condition precedent, my dear friends, was before you could get to Section 1774 to raise an issue of the qualification of the president as a result of an interpretation of the Constitution. You first had to have a declared winner. And if the winner is declared, as in this case, I hope it will be very soon, and there any irregularities, fraud, personation, whatever have you, you have to take it to the High Court under Section 163. And what the CCJ made absolutely clear, that condition precedent would require a trial of considerable length or no length at all if there is no evidence, because many election petitions in the OECS fail because the petitions are so badly drafted, they reflect the fact that no evidence exists. And in these jurisdictions, the petition must disclose a perfected cause of action within 21 days. But more importantly, for the full understanding of the condition precedent that my brother Sanjay spoke about, is that after the trial, you have a right of appeal to the Court of Appeal. And after that right has been exhausted in the Court of Appeal in Guyana, you then have a right of appeal to the CCJ. So for the people of Guyana, my friends in Guyana, to fully appreciate what was being said, they could not have invoked Section 1774 until the trial, the appellate process in the Court of Appeal, and the appellate process in the final court is completed or are completed, because I said proceedings. And a single named president is declared at the end of the process, the president of the Republic. Is it Republic? President of the Republic of Guyana. So there were many months, if not a year or 2 years, premature. I wanted your listeners to fully understand what Sanjay meant by condition precedent. I can't hear you, Joe. Your mute is on.
Yeah, thank you for that, Senior. And Senior, I want to come back to you with something. I'm afraid I'm going to ask you to repeat. But for emphasis, it is important we repeat some of these things just to let our viewers and listeners know that, ladies and gentlemen, based on what we are reading and what we are seeing, especially out of Chairman Claudette Singh's instruction to Lowenfield today, he has no wriggle room.
I was about to
to
ask
go
that.
back.
That's a very good question,
Yeah, he
right?
does not have any wriggle room. So, Senior,
Mhm.
the paragraph 47 of the CCJ's decision says that by the unnecessary insertion of the word valid, the Court of Appeal impliedly invited the CEO to engage unilaterally in a further and unlawful validation exercise, to your point that you made earlier, Senior. And in its summary and orders, the CCJ's decision reads, logically, the report of 23rd June issued by the CEO, which was based on it, is similarly of no effect. It follows that the appeal of Messrs. Ali and Jagdeo succeeds. Senior, could you kindly take some time and assure me and my brothers and sisters across Guyana that the CEO has no wriggle room to act on it?
I'll be as honest as I can be. He has no lawful wriggle room. He has no constitutional or lawful wriggle room. What they may do tomorrow and conjure up, because many of us are extraordinarily creative. All I can say is that there's no constitutional or lawful wriggle room in the light of the decision of the CCJ, the unanimous decision of a very strong bench of the CCJ, and the very clear language. And I like the fact, I think Sanjay had sent it to me. Let me see if I can pull it up. I like the first sentence. Section 18 of the election, Section 18 of the election laws, number 15 of 2020, stipulates that you are subject to the direction and control of the commission. These are important words.
Yes.
So he has received a constitutional and lawful direction that you must give us the results on the certificate of returns that were published and shared with all, without machinations, without any form of magical disappearances or anecdotal stories about it. I thought it was only in Dominica people complained about the dead voting. I didn't realize that there was a trend in Guyana as well. I mean, the leader of the opposition actually said on radio that he saw dead people vote, and we've been trying to get him to show us the pictures, but not yet.
We had that here too. A member said he actually witnessed somebody vote, some person that doesn't exist voting. Sanjay, Mr. Datadin, I want to come to you on one of the points that I feel is extremely important. Counsel Lowenfield, a week and a half or 2 weeks or whatever time ago, he said no one can instruct him. He believes that he is independent. He believes he's a constitutional appointment and nobody could instruct him. What is to stop Lowenfield from getting legal advice? I mean, that's a silly question maybe, but is there anything that could stop Lowenfield from deciding that he interprets this phrase within the chairman's letter to say he cannot comply? And he feels he cannot comply with her letter, and her letter is an illegal instruction, unlawful instruction, sorry.
Are you talking about the fourth sentence there, which is Section 18 with the City Council? Which one?
Yeah, both. I'm talking about the entire letter, that he will say, I disagree with what is said here. I disagree with your interpretation of Section 18. I disagree with the way you're putting 177.2. Here is what my lawyer is advising me.
Yog, I would put it to you this way. I know Mr. Lowenfield, so I could offer him only friendly advice. The first thing is that he should realize that there are criminal charges that allege that he is guilty of fraud and misfeasance in public office. Now, he said that he relied on the Court of Appeal before, so he might be able to say that. But if he's to read the judgment of the Caribbean Court of Justice, it is clear and direct. The letter that he received from the chairwoman is clear and direct. He will be best served so that he could preserve his own liberty, that he should comply with what he knows and what is expressed to be. Mm-hmm. Now, as Senior Counsel said, there is no lawful wiggle room. There might be persons who might want to encourage him, or attorneys who might want to encourage him to suit their purpose. But he is capable of reading, and he should read the judgment himself. He is capable of checking the provisions that Justice Claudette Singh made reference to in her letter, and he should read those provisions very clearly and see whether he has any independence. I have said to people before, when 177 says that the chairman must act on the advice of the CEO, it is not advice of how to fly a plane. It is not marriage counseling advice. It is not advice how to drive a car. The advice is simple: to give the advice about the votes. Mm-hmm. And the deeming provision of that section says that someone is deemed to be elected if they have the most votes. And mm-hmm. you have to figure out who has the most votes. So he is responsible for all of the returning officers who did all these counts. He is the apex of the Secretariat. So it is his staff who did that. It is his staff who determined what was valid and filled out all those statements of recount. If you look at the statements of recount, they state valid votes.
Okay.
These are the valid cast. Now, mm-hmm. what he wants to do, I understand what he might want to do, or what he might feel he's entitled to do, and what people around him might encourage him is his power. But he has no power to deal with validity of votes. He has no authority to enter into that fray. His job is very simple: to tabulate the recount SORs for the 10 regions, calculate the seats, and inform the chairman. Now, anything else, Yog, mm-hmm. is not provided for. It is foreign to his powers and his authority. And it's a very simple thing. Mm-hmm. When he thought he could simply disregard 115,000 of my countrymen and their votes, the court said very clearly that that is arbitrary and it's seemingly not transparent.
Right.
So how did he come to that? So he would be best served for his own interest, mm-hmm. for protection in the court cases that he has filed, the criminal charges.
But, Counsel, let me come back to you and Senior. Senior, there are two questions I have. And I know that we might be taking a circuitous route here because you did deal with this in a way, Senior, at the top of the program. Now, Madam Chairman's letter to Lowenfield specifically speaks to Section 18, in which the commission can instruct him. And paragraph 2 speaks to 177.2 and Section 96 of the RPA. This letter does not infer or refer to the CCJ's decision, but it does say using valid votes in the national recount. Might not Lowenfield say, I do not have to go to the CCJ. That has nothing to do with my role here. I have no other guidance. And again, I will prepare valid votes using his warped interpretation of valid again and we are back at square one. I just want to ensure we dot the I's, cross the T's on this, Senior. And the next question to you, Senior, I've just received a question directed at you, actually, from a senior human resource manager that says, is there any difference in Madam Chairman's choice of words, "you are hereby requested," versus "you are instructed"? Because if you're under the direction of GECOM, why didn't she say "you are instructed"? See, Counsel, I told you we have a lot of lawyers, huh?
Let me just show you section 18 of the act that the judge referred to. Said the Chief Elections Officer, the Commission of Registration, shall notwithstanding anything in any written law be subject to the direction and control of the Commission. That is the section quoted by the chairperson. I think most people who are acting bona fide and lucid and sane, that receives a letter that says you are subject to the direction and control of the Commission, and the section is cited, and it says you are hereby requested. That is a formal demand. She didn't ask, well, if you don't mind, would you please? You are requested, and she's very specific what she's requesting. She's not requesting him to resubmit his report, it having been declared unlawful by the CCJ. She would never have asked him for that. That is a dead duck floating somewhere down the Demerara River. It's dead. Okay? She's asked him by 2 p.m. tomorrow, the 10th, using the valid votes counted in the national recount as per certificates of recount generated there. So he has to supply the information on the certificates of recount that were generated. And he cannot embark on the process that the CCJ has declared to be unlawful and unconstitutional about making determinations of migrant workers or dead people and so on. I mean, it's to me, a very clear instruction has been sent out to Mr. Lowenfield, and no amount of trickery is going to be able to get out of the clear language. I mean, this letter begins with a clear command: you are subject to this direction coming from me, the chairman of GECOM.
And don't forget, Yog, my apologies. Don't forget, Yog, that it was Lowenfield himself who would have said that he's a constitutional officer, and so therefore she is, in this very first line, striking that out. She's saying that you are under the direction and control of the commission. I think there's another way of looking at it too. She's saying that if you fail to do this, could it be, could we read it that if you don't do it, that you could be very well fired, to use Guyanese terms?
Is that directed at me or Sanjay?
Both. All three lawyers.
Sanjay, you open the button on this one.
I think, Leonard, there is another thing. Remember a couple of days ago, there were a couple of videos that were making the rounds of Lowenfield in 2019 and 2015. And he went to great pains to explain to the press that he would only act on the instruction of the commission, that whatever is required, he has to get an instruction from the commission, and he is ready to do whatever it is they said. This was when we were saying that he should have elections should be held within 3 months of the no confidence motion. So he made it clear that he can't take any decisions on his own and that he must act on the direction of the commission. In relation to what Justice Claudette Singh really means when she says to him, you are subject to the control of the commission and quotes the things. I mean, look, if your boss tell you, listen, I am your boss, and this is what you're required to do, I believe it's making it clear and making it abundantly clear why it is that you must obey the instruction that is given to you. I don't think, it would go into speculation whether it is that Justice Claudette Singh is saying she will fire him or anything along those lines. I interpret it a little bit more differently. I think that what she's doing is, having requested the report on the previous occasion, 16th of June, from him, and him when Mr. Lowenfield having gone on a frolic of his own, I think she's trying to narrow down. You're subject to the commission, notwithstanding what is written anywhere else, that I would like you to present a report because Section 96 say you must present a report. And I have to make a declaration in accordance with Article 177 of the Constitution. And the Constitution says I have to receive the numbers from you. So in relation to all of these things, you're subject to my direction. And I'm saying to you, please use the recount data and present your report to me. So I believe that, as opposed to it being interpreted as if you don't comply, you could hit the road, I think it is more designed towards, listen, let me spell it out and point out to you step by step. Lay the crumbs on the ground and get Hansel and Gretel home. I believe that it is a directed thing. You don't have to think. All you got to do is follow the dots. And what I believe the Justice Claudette Singh was doing in her role as the chairman was saying to him, these are the clear parameters. I have to make a declaration in 177. I have to receive these figures from you, and you have to give me these figures from Section 96. But know this, under Section 18 of the Act, you're under the control of the Commission. So I'm telling you how to go about doing your job in case you have any doubts.
Right.
So don't go on a fishing expedition. Again, don't go off on your own and remove persons from it. She's as clear can be. Now, that could be both sides, Leonard. That could be so that if now there is a mistake or if something untoward were to happen, she would then be free to take the ultimate action that she might want to. But I think more of a signpost that, look, follow this and you'll get home safely.
Thank you very much.
So thank you for that. And Senior, I hate to be pushing on this. We got a couple of minutes more to go to wrap up tonight's program. It's been a pleasure to have you here, Senior. I just want to ensure everyone out there that the wriggle room we spoke about, the possibility or lack of possibility of any wriggle room, legal wriggle room, to use Senior's words, for the Chief Elections Officer, there seems to be no legal wriggle room. Senior, the reason I've been coming back to this question is because the political parties, proponents and advertisers and so forth, has actually hit all of social media this afternoon by saying that the letter has valid votes, and he has already prepared one report of using valid votes, and all he's going to do is take out any definition or any reference to this Court of Appeal, and he will come back to this same report. So I just want to ensure people out there understand that Section 96 of the Representation of People Act is the one so Madam Claudette Singh, ladies and gentlemen, has not missed the ball. She has directed him to look at 96 in the Representation of People Act. And Counsel Senior, correct me if I'm wrong, but it is Section 96 that directs Lowenfield as to how to interpret that word valid.
No, let's be very clear what she said.
Sure.
She didn't say just valid votes. She said using the valid votes, meaning as far as she's concerned, they all are using the valid votes counted in the national recount as per certificates of recount generated therefrom. In other words, he has to give her because I showed you just for the purposes of your audience the form.
Yes.
And the mandate under Section 89 requires them, after the count, to identify the total valid votes. And I explained before, and as we ended, and it's an important point, I'll just make the point again. All votes are presumed valid. And if a vote is counted without a questioning the preliminary count, or without a declaration of invalidity by the presiding officer, every vote counted, which is listed on Form 24, which is the certificate of recount, is a valid vote.
Yes.
Is a valid vote. And the only way these votes could be set aside, as the CCJ was at pains to explain, and Sanjay for the last year trying to explain, it could only be set aside by an application for petition, by a petition, to the election jurisdiction of the court.
Right.
I mean, why do you think, just for your listeners, why do you think that the what's the word again? The statement of poll is declared on publication in a conspicuous place as the conclusive evidence of the result of that count of the votes. And in this statement of polls would only reflect valid ballots, because the presiding officer is mandated not to count and to put rejected ballot papers in the same box. They have to put it in a very different envelope.
Correct.
The same with the count with the returning officer. He can only declare valid votes invalid if the mark was missing, if there was no proper declaration of vote mark, X or cross, whatever you call it in Guyana, to show how somebody voted or the name of the elector was disclosed. Once that process has passed, there is no authority in the Chief Elections Officer or GECOM, as the CCJ strenuously asserted, to declare any other ballot counted and reflected in the certificate of return to be declared unlawful or illegal by the Chief Elections Officer, GECOM. So all ballots right now that are stated as declared, number of valid votes cast. I mean, that's what it says.
That's right.
Number 2, total valid votes for all lists. And the second page says the number of spoiled ballots, the number of tender statement of rejected ballots, number of ballots rejected for want of official mark, unmarked, or void for uncertainty, marked for more than one candidate list, or marked for the... In other words, the Form 24 requires them to show the votes and the number of votes that in the counting process that was declared invalid. And those that do not fit on the second page of Form 2 as an invalid vote or rejected vote are by law valid ballots. So the chairperson of GECOM is merely asking you to give me the numbers on that list that have been counted at the preliminary count and the recount as valid votes and were not rejected or declared invalid for the reasons given in the representation of the People's Act.
Yep. Thank you for that, Senior. And ladies and gentlemen, there you have had it, a very clear, very transparent, very, very, very lucid explanation of not just the laws that we have to now follow, but of the absolute path that is ahead of the CEO now giving this instruction from the chairman of GECOM. And we are at the end of our program, ladies and gentlemen. Senior, it has been an absolute privilege and pleasure to have you in room 592 tonight, sir. I do hope we'll be welcoming you in the near future for you to tell us, job well done, elections are now out of the way. I hope we don't see you under similar circumstances again, Senior. But it's
I
been
hope
an
not.
absolute, it's been an absolute pleasure to have you. Thank you, Senior. And Counsel Sanjeev Datadin, thank you so very much for being here with us tonight.
Leonard.
Thank you.
Thank you, Tony, for being with us. Thank you for all your assistance. And when I see you next time, I definitely owe you a drink. And thank you for coming.
You know what that means, Sanjay? You owe me two.
Yes, I do.
Great.
I do, buddy.
Well,
Take
thank
care.
you so
Bye-bye.
much.
Thank you.
And thanks again, Senior. And ladies and gentlemen,
Good
this has been a wonderful chat from room 592 tonight, as we say thank you to our esteemed guests here tonight, and thank you to Mr. Datadin. And I do hope that we don't meet again tomorrow night to see that the goalposts have shifted again. We all do look forward to a declaration very, very, very soon. And we are now out of our time. As I say goodbye to you all. Looking forward to see you tomorrow at 1:30 on our Elections Watch with Mr. Leonard Gildari. Sanjay, thank you so much. My co-host,
Thanks.
Mr. Gildari, thank you.
Thank you.
Ladies and gentlemen, remember to say a prayer for Guyana. Good night.